Provisional patent applications are popular with startups and inventors because they're fast and relatively inexpensive, but they're also one of the most misunderstood tools in the inventor's toolkit. Yes, they're inexpensive, flexible, and don't require formal claims, but they're not a shortcut to a patent. Let's bust 5 of the most common myths about provisional patent applications so they don't trip you up later. Here's misconception number 1. A provisional patent application gives me a patent. Nope. A provisional patent application is not a patent. Based on inventor questions I see on Reddit and Quora, inventors should have to write this on the whiteboard 100 times before filing a provisional patent application. Here's the truth. A provisional patent application is essentially a temporary filing that holds your place in line at the USPTO for 12 months. To get an actual patent, you must file a non-provisional application before that year runs out. The USPTO does not examine your provisional application, and it will never result in a patent on its own. While a provisional application establishes an early filing priority date for your invention and allows you to use the phrase patent pending on marketing and other informational material, you can't sue for infringement based solely on provisional application. You do not have legally enforceable patent rights against infringers until a patent is granted based on a non-provisional application. So here's what to do. Use the provisional application to secure your filing date and work with a patent professional to do it correctly to maximize the chances of your full non-provisional application being granted as a patent that protects what you want it to protect. Also, do use the term patent pending as I described, as that can be a deterrent to infringement. That phrase does make people aware that a subsequent non-provisional application may be filed and published, at which point they may be found to have actual legal notice of potential patent rights. That could leave them liable for infringement retroactive to the publication date if a patent eventually issues from the non-provisional application. Here's misconception number 2. As long as I file something, I'm covered. That's simply not true. The quality of your disclosure matters a lot. Here's the truth. Your non-provisional application can only claim priority to what was actually disclosed in the provisional application. If key elements weren't clearly described, you won't be able to claim the provisional application priority filing date for those features in the non-provisional application. This mistake is common with rushed, vague, or minimalist filings. I do see it regularly where people come to me to handle the non-provisional application based on their DIY or online service provisional application. Sometimes those provisional applications are even useless. Rushing to get a filing date is pointless if you can't take advantage of that filing date because the provisional application was too sloppy or lacked sufficient detail. Here's what to do. Treat the provisional application like the technical legal document that it is. Fully describe all variations, features, and possible uses of your invention. If it's important to your invention or your business model, take the time to put it in the provisional application in clear terms. Here's misconception number 3. I can publicly disclose my invention after filing and still be safe. This one is a half-truth that can still be profoundly risky. Here's the full truth. In the U.S., you do have a 1-year grace period after public disclosure to file a non-provisional patent application. But that's not true everywhere. Public disclosure can kill your chance to get patent rights in another country. In many other countries, public disclosure before filing a full international application can stop your ability to get patent rights in those countries entirely, even if you file a U.S. provisional application before that disclosure. Here's what to do. If you plan to file internationally, or even are thinking that you might, avoid public disclosures before filing both your provisional application and your non-provisional application, as well as the international application. A patent attorney can help you negotiate the tricky details of the timing regarding applications and public disclosure, as well as what counts as public disclosure. They can help you know when to use a non-disclosure agreement to prevent public disclosure too. Here's misconception number 4. I don't need a patent attorney for a provisional application. It's tempting to save money by going it alone or using a low-cost online service, but that isn't always wise. Here's the truth. Legally, you can file on your own, but many DIY provisional applications don't hold up later. Most DIY provisional applications and ones done through a low-cost online service, even the ones with attorney assistance, lack the detail needed to fully support a later non-provisional patent application. That weakens your intellectual property and could lead to costly rework or worse, unavailable rights. Without the proper structure, terminology, and legal foresight, you might miss important disclosures that limit what you can claim. Many inventors end up needing to refile entirely and lose that early filing date from the provisional patent application. Here's what to do. At least consult with a registered patent attorney. Many offer flat fee or review services for provisional applications. It won't be cheap, but it's money well spent, especially compared to the cost of attempting to fix an insufficient filing. Here's misconception number 5. Once I file a provisional patent application, I don't need to worry for a year. Filing a provisional patent application doesn't mean you can forget about that application or the invention for 12 months. That time goes fast, and you need to use it strategically. Here's the truth. You should be finalizing your invention, researching competitors, and working on the non-provisional application. Waiting until month 11 often leads to rushed filings or missed opportunities. You know from previous points why rushing an application is a bad idea. You know from previous posts why rushing an application is a bad idea. Here's what to do. Treat that 12-month period like a countdown, not a cushion. Work consistently to move your intellectual property and your business forward. Finally, here's what I hope you take away from this post. A provisional patent application is a tool, not a shortcut. Used correctly, a provisional patent application gives you time to explore your invention's potential, seek funding, and test the market. Used incorrectly, it can create a false sense of security. Before you file, get clear on what a provisional patent application can and can't do for you. A consultation with a patent attorney will likely save you significant time, money, and heartache in the long run. Talk with the attorney about what the provisional patent application should contain and how to align the application and filing date with your long-term goals. What you do in the provisional patent application stage can determine whether you end up with a strong patent or no patent at all. If you'd like to consult with me about patents or other intellectual property issues, you can use my website contact form, or you can book a consultation online at kingpatentlaw.com or by calling my office at 312-596-2222 or 217-714-8558. Please check out my website, LinkedIn profile, YouTube channel, podcast, and other social media for more information on patents and other intellectual property and business law issues.